Good afternoon, sir.
Yes, very good afternoon.
So, in our today's edition of our weekly Saturday webinar, we will be focusing on the topic of the jurisprudence of anti-dumping laws. Uh, this will be in a question and answer format. So, sir, to begin with, I would like to ask you, what does the term dumping mean, sir? As to what is dumping in international trade or in the jurisprudence of anti-dumping?
Thank you very much, Dev, and good afternoon, everyone. So, you see, the concept of anti-dumping means that you see a country is exporting some product at a price which is less than the normal price. So, suppose the price of a product is say 100 rupees ordinarily, at which they are selling it in the domestic market, then in order to capture the foreign market or to destroy the local industry in any foreign market, they export it at even lower than their normal price, even below the cost. And by doing that, say, suppose your product value is 100 rupees ordinarily, it will be sold at 100 rupees. Now, suppose from country A, say, for example, let us take the example of China. China regularly does anti-dumping in various foreign jurisdiction, and because of which they have managed to destroy and damage the local industry. The local industry is shut now. And now, since the local industry do not have the manufacturing ability or their industry has been shut down. So once the local industry is shut down, then the the exporter has the total control over the market, and they are able to sell the price or charge the price which they like. So not only the local employment is destroyed, the local industry is destroyed, but the consumer is also affected in the process. Uh, it is, in a way, if suppose this thing happens in a local jurisdiction, then it is called a, there is a concept of predatory pricings. That means suppose a big multinational giant or even a domestic company, let's say a big corporate which has a lot of money to burn, they set up a manufacturing, they start selling their product at below the cost, and in order to destroy the small producers of the same item, and over a period of time the local industry gets extinguished, and the big player has all the the total control over the market or sort of a monopoly over the market. So this happens not only in the foreign jurisdiction, but also in the international market, where some big multinational giant, or suppose with a country like China, where the domestic industry has also the support of the local government, because the Chinese government, as far as I know, they provide subsidy to the Chinese producers, and then they export it in various jurisdictions and completely take over the market, by process of which the local industry is totally damaged.
So then, how is
So,
the anti-dumping measure defined, sir? And what is the primary objective that this measure intends to achieve?
so the primary objective is the level playing field. Some people call it a measure to protect the domestic industry, or is a protectionist measure. But the fact of the matter is that it is not a protectionist, it's not a measure to give protection to the domestic industry, but rather it is a measure to create a level playing field. Now, how? Because the anti-dumping is imposed only to the extent of difference between the normal value of that market, normal value of a product, and the export price. So suppose a domestic, say Chinese supplier, he is exporting a toy in Indian market. Now that toy is available or is being sold at 100 rupees in the Chinese market. But the same toy, in order to have a competitive price in the Indian market, they the toy manufacturer will sell it at say 80 rupees in Indian market. So this difference in the normal value at which he is selling in his own market and the price at which it's selling in the foreign jurisdiction, this is called the margin of dumping. And anti-dumping duty can be imposed only to the extent of margin of dumping. So first of all, the normal value is determined, the export price is determined, margin of dumping is determined, and then to the extent of margin of dumping, the anti-dumping duty can be imposed. It is not for the protection.
Sir, now that we have an idea of what anti-dumping duty is, could you tell us something about who can file an application for anti-dumping duty?
Right. So the applicant in a anti-dumping to be an anti-dumping applicant, one of the criteria is that you must be a domestic industry. That means suppose a toy, I give you an example of toy, so I continue with that. So a toy manufacturer in India who is producing the like article, that means there are several criteria to know what is the like article. And I recommend the study of, there is one manual of operating practices for trade remedies and investigation, which is available on the website of Director General of Trade Remedies. So it has detailed discussion on what is like article, and we will continue with the discussion in next sessions also. We will go into the depth of the concept of the like article. But for the time being, I limit my observation by saying that a like article means an article which is identical or alike in all respect. So if suppose Apple is being exported from China, then there has to be an apple to apple comparison. So somebody who is a manufacturer of Apple or its ally, suppose any item which is can be a substitute for what is being exported, that can be considered. So there are various criteria. What is the size? What is the technical characteristics? What is the item known? It may be possible that one changes the description of the product and tries to dump it, but that is not permissible. That is another matter of discussion. We will discuss later on. But essentially, it has to be like article. And once there is a like article being manufactured by a domestic industry, then that domestic industry can file an application. But in order to file an application, there must be a minimum of 25% of the domestic manufactured. So one or more person can come together and file an application. But if one or more person is coming together, then the out of the total production in the domestic market, that is, suppose if a dumping is happening in India, then at least the domestic industry who is making an application for levy of anti-dumping duty, they must be manufacturer of at least 20% of the total production in the country. So if suppose 1,000 units are being manufactured
Sir, in
in
this regard, I
India,
had a question, sir.
yes, yes,
If there is an association,
correct.
so if it has the requisite of being filling the threshold, but will that association be eligible to file an application?
Yes, yes. Association can also file an application on behalf of the domestic industry. For that, there is a circular which has been issued by the Director General of Trade Remedies, and which says that the following information will be examined to establish their claim that whether the association is registered. A list of members will have to be given. A copy of the meeting in it was resolved that the association can file the anti-dumping application on behalf of some or all of its members. A list of members who have either supported, opposed, or remained neutral, or any other information. So a detailed, detail will be taken, and if they satisfy the criteria, then even an association can file.
So my next question would be, so that how is an anti-dumping investigation necessarily made, and who needs to be heard before the recommendation of the levy of the uh, anti-dumping duty?
Okay. So the application, first of all, it should define what is the product, because the most important thing is that it should be a like product. And to ensure that it is a like product, the product under consideration, PUC for short. I mean, in the there are some specific terms which is used in the context of anti-dumping application. And product under consideration, or what it is called PUC for short, is very important to be determined. So the application should be a detailed one. And while filing the application, a detailed description of the product and how it is similar in physical, technical, or other properties, or technical information which would facilitate the exact identification of the product at the time of collection of anti-dumping duties, its tariff classification. So all those details have to be provided. And since the production percentage should be minimum 25%, so a detail about the total production in the country and how they are crossing that threshold of 25% has to be given. So the application, you see, should focus on three things. One is product, which is under consideration, that is PUC. Second is to give a detail about the export price, normal price, and how the injury is taking place, how the import of the said product or the product under consideration at less than the normal value is affecting or destroying the domestic industry.
Sir, I had a question regarding the concept of PUC. How essential is it regarding the carrying out of an investigation?
You see, I've already explained that the PUC is the main thing, because it tells you whether you are crossing that threshold of being an applicant of the like article. That means you are manufacturing the same item which you are alleging to be dumped into India. So that is very important.
Yes, sir. So now, can you also tell me a little bit about this topic about domestic industry that you defined earlier on? I had a question regarding that.
Yes, sir.
Can an importer necessarily be excluded from that definition? Suppose he's importing a product and
Right.
he's also utilizing the same in the market. Would it fall under the definition of domestic industry?
Okay, so that is a very pertinent question, or rather, I should have told you earlier that in order to qualify as a domestic industry, because a domestic industry can be the applicant, provided that threshold crosses the threshold of 25%. So the domestic producers means those who are engaged in the manufacture of the like article. So two things is very important. That one is that you should be a manufacturer and manufacturer of the like article. So a trader cannot make an application. Only a manufacturer can, a manufacturer of the like article. But suppose I am an importer of the dumped article, then I am excluded from the definition of domestic industry. So suppose there are 5 domestic manufacturer and I am somebody who is manufacturing as well as importing. So even though I qualify, I cross the threshold of being the domestic manufacturer, but since I am myself importer also. So there will be a conflict of interest. So to avoid that conflict of interest, I am excluded from the definition. But at the same time, it is not that in all cases the importer has to be excluded. It has to be looked into what kind of what is the circumstance or what is the quantum of the import vis-a-vis his manufacturer, whether he is primarily a manufacturer or primarily a importer. Suppose who is somebody who is an occasional importer, in order to only I mean to sometime to plug the gap of the excessive seasonal demand or something like that, or some temporary, you see, disruption in his manufacturing ability. So it has to be seen whether he is primarily a manufacturer or primarily an importer. So if we can satisfy that this import is only incidental and his primary activity is that of a manufacturer, then he cannot or should not be excluded. And in this regard, there are two judgments which I would like to point out. One is the judgment of the Honorable Calcutta High Court in the case of State of Gujarat Fertilizers and Chemical Limited versus Government of India, reported in 2012, SCC Online Cal 8071. And another judgment is of Century Plyboards India Limited and another versus Union of India and others, reported in 2022, SCC Online Guwahati, page number 643. So these are the two judgments which says that in all cases it is not necessary that importer has to be excluded from the definition of domestic industry who can be the applicant. So in appropriate cases, the importer can even be included with the purview of the domestic industry. And this is also important from the perspective of determining the status of the applicant. Because somebody, suppose, who is a manufacturer in large quantity, and if he is excluded from the definition just because he is an occasional importer and he himself controls a majority of the market, then it will be difficult to find an applicant, because it may be possible that the collective strength of the rest of the manufacturer may not be enough to come together to file an application for imposition of anti-dumping duty. So a circumstantial situation has to be looked into.
Hello, sir. Very good afternoon, sir. I have a very quick question.
Yes, yes, tell me.
Yes, sir. My question is, can the similarity or dissimilarity of the product process determine the like article?
Similarity?
The similarity or dissimilarity of the production process determine the like article?
No. In this regard, I think I can refer to the Manual of Operating Practices for Trade Remedies, and which defines the like article. It gives a detailed description of what can be or cannot be the like article. And it is very categorically said that the domestic, the production process or the process of manufacture is of no consequence in a trade remedy investigation, as the same goods may be produced with different production and technology process. And it is also possible that the different production process results in different physical characteristics, but they satisfy the criteria of being the like article. So the criteria is like article, whether it is manufactured from the same production process or different production process, it does not matter. Because we may not be in a position even to know as to what is the domestic, what is the process being employed by a exporter to manufacture his item. An applicant may not be in a position to give detailed description of the production process, and it may be confidential also in nature to give a detailed description of the production process. So even a applicant need not even give the details of the production process because it may be a very confidential information.
Well, in this regard, I had one question regarding the confidentiality of the process. So the question is, in an application of levy of anti-dumping, some
Right.
information can be marked as confidential, but how far is it binding on the adjudicating authority to consider that particular information to be confidential or as not confidential?
You see, confidential information is defined in Rule 7. So, first of all, you see, before I answer your question, I think I should have told you that the legal, you see, power to levy anti-dumping duty arises from Section 9A of the Customs Tariff Act 1975. Now, the central government may appoint an authority who is called an anti-dumping authority to investigate whether the dumping is taking place or not. And that authority is called the anti-dumping authority. Only after a recommendation is made by the anti-dumping authority on investigation, after the replication is made to the anti-dumping authority, that anti-dumping to levy or not to levy anti-dumping duty can be recommended by that adjudicating authority. Now, the rule governing the process of application and how it is to be dealt with is prescribed in Customs Tariff Identification, Assessment and Collection of Anti-Dumping on Dumped Articles and for Determination of Injury Rules 1995. Now, Rule 7 of that rule, which I have just talked about, says that the anti-dumping authority and applicant can always classify the information which is providing as a confidential in nature, because a copy of the application, non-confidential version of it, has to be provided to all the interested parties. Now, who are the interested parties? Who can object to the anti-dumping duty? What is the detailed process? We'll discuss in the next session, because I think it is better that we curtail our discussion to half an hour on a particular day. We'll upload today's discussion on YouTube. So anybody who has not attended today's session can always watch our today's session on my YouTube channel. And we'll continue this discussion in the on next Saturday, because I don't want to stuff too much of information in a day, which may be difficult to understand. So I want to limit my discussion to half an hour. So today, I think I will conclude with discussion of the aspect of the confidential information, and I will continue about it in the next session also about the confidential information, because there is a Supreme Court judgment also on this. But to refer to Rule 7, if the designated authority is satisfied that request for confidentiality is not warranted, or the supplier of the information is either unwilling to make information public or to authorize its disclosure in a generalized or summary form, it will disregard such information. So the designated authority who conducts the investigation, they can always classify an information which has been provided at the time of making application as confidential or non-confidential, depending on the reason provided for keeping it confidential or the detail of the reason. Yes. So I think we should end today's discussion with this, and we continue with this in the next session on next Saturday.
Yes, sir.
And
Indeed, it was a very insightful session, sir. Thank you so much.
and we'll upload it on YouTube so that anybody who wants to, you see, who could not attend or who have attended late, they can always watch it on YouTube. And the next session also, before attending the next session, they can watch it on YouTube and join me on the next Saturday. Thank you.
Thank you, sir.